Okay, I need to tell you something, and I need you to stay with me here because this is important. In the past year, the United States has witnessed something we haven't seen since the founding of the Republic: a sustained, systematic confrontation between a sitting president and the federal judiciary that has pushed our constitutional system to its breaking point. I'm not using that phrase lightly. I don't say things like that for effect. What I'm about to walk you through tonight is the documented record of what happens when a president decides that court orders are suggestions, when federal judges are labeled enemies, and when the machinery of accountability starts grinding against the machinery of executive power. This is the story of one judge, one president, and a constitutional crisis that most Americans don't even realize is unfolding. Let me take you back to Saturday, March 15th, 2025. At that moment, planes were in the air. Deportation flights carrying Venezuelan men the Trump administration claimed were members of the Tren de Aragua gang. The administration had invoked something called the Alien Enemies Act to carry out these removals. Now, here's what you need to understand about the Alien Enemies Act. It's a law from 1798. Let that date sink in. This law is older than the Louisiana Purchase. It predates the War of 1812. It was written when John Adams was president and the young republic feared war with France. The Alien Enemies Act had been used exactly 3 times in American history, all during actual declared wars. World War I against German and Austro-Hungarian nationals. World War II against German, Italian, and Japanese nationals. The law was designed for wartime deportation of citizens from enemy nations during active military conflict. The Trump administration decided to use it against alleged gang members from Venezuela. No declared war, no congressional authorization, no military conflict with Venezuela, just an executive proclamation declaring that Tren de Aragua, a criminal gang, constituted an invasion of the United States. Think about what that means for a moment. The administration took a wartime authority, one that bypasses virtually all due process protections, and applied it to immigration enforcement during peacetime. Legal scholars called it unprecedented. The ACLU called it the administration's most extreme measure yet. Chief Judge James Boasberg of the U.S. District Court for the District of Columbia looked at this and said no. He issued an emergency order blocking the deportations for 14 days. And then, in an emergency hearing that Saturday, he gave a direct verbal instruction to Justice Department lawyers. I want you to hear exactly what he said, because these words matter. Boasberg told the government attorneys, however that's accomplished, whether turning around a plane or not embarking anyone on the plane, I leave to you. But this is something that you need to make sure is complied with immediately. Immediately. Turn the planes around. Return anyone subject to this order to the United States. Stay with me here because this is where it gets extraordinary. The planes did not turn around. The Justice Department later claimed the flights had already left U.S. airspace. But here's what the evidence showed. Flight tracking data reviewed by multiple news organizations indicated that both flights had not yet landed when Boasberg issued his directive. Justice Department lawyers, when questioned by Judge Boasberg, confirmed that his instruction was promptly communicated to federal officials overseeing the flights. They knew, they were told, and the planes kept flying. They landed in El Salvador. More than 200 men were sent to a notorious maximum security prison called SCOTUS, the Terrorism Confinement Center. This is a facility that has drawn international condemnation for its conditions, and the president of El Salvador, Nayib Bukele, posted on social media that night. His message, and I'm going to read it to you exactly, was this: Oopsie, too late. Let that sink in. A federal judge issues an order. The executive branch is informed of that order in real time. And a foreign head of state mocks the American judiciary on social media while planes carrying deportees land in his country. If you're finding this valuable, hit that like button right now and subscribe to this channel because this story is far from over and you're going to want to follow what happens next. Now, here's what followed that weekend. On Monday, March 17th, Judge Boasberg held another hearing. He wanted answers. How many flights were there? How many people were on them? Who gave the order to continue the deportations after his ruling? The Justice Department attorney, Abhishek Kambli, refused to answer. He cited national security concerns. When pressed on basic questions about timing and decision-making, he said only, I am only authorized to say what we have said in the court filings. Boasberg's response was direct. He summarized the administration's position as, we don't care, we'll do what we want. And then, just before that hearing, the Justice Department sent a letter to the appeals court asking to remove Boasberg from the case entirely. They argued he was endangering national security by asking questions about the deportation flights. Think about that sequence. Defy the judge's order, refuse to answer his questions, then try to get him removed from the case. On Tuesday morning, March 18th, President Trump escalated further. He posted on Truth Social calling for Judge Boasberg's impeachment. He called Boasberg a radical left lunatic who was sadly appointed by Barack Hussein Obama. He said the judge was not elected president and should be impeached. Within hours, something remarkable happened. Chief Justice John Roberts, the head of the United States Supreme Court, issued a public statement. This is extraordinarily rare. Roberts almost never comments on political matters. The Supreme Court as an institution prizes its independence and typically stays above partisan combat. But here's what Roberts said, and I want to read this exactly. For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. Let me break down why this matters. The Chief Justice of the Supreme Court, a conservative appointed by George W. Bush, the same Chief Justice who wrote the opinion granting presidents broad immunity from criminal prosecution just months earlier, felt compelled to publicly rebuke a sitting president, to remind him and to remind Congress and to remind the American people that judges cannot be removed simply because a president doesn't like their rulings. Federal judges in America serve lifetime appointments precisely so they can make unpopular decisions without fear of political retaliation. That's the design. That's what separates us from countries where courts do whatever the leader wants. And here's the thing, this wasn't the first time Roberts had to do this. Back in 2018, during Trump's first term, the president attacked a judge who ruled against his asylum policy as an Obama judge. Roberts responded then too, saying America doesn't have Obama judges or Trump judges, Bush judges or Clinton judges. That the independent judiciary is something we should all be thankful for. In 2020, Roberts issued another rare statement after Senator Chuck Schumer made threatening comments toward Justices Gorsuch and Kavanaugh at a rally. Roberts called those statements dangerous, but the March 2025 statement was different in kind. It came after an administration had already defied a court order. It came as members of Congress were filing articles of impeachment against Judge Boasberg. It came as the President of the United States was actively calling for a federal judge's removal. The stakes were real. The threat was real. Now, I need to tell you what actually set this off, the deeper context that most coverage is missing. Judge Boasberg didn't let this go. He spent months trying to find out what happened on those March flights. He held hearings, he demanded answers, he gave the government multiple opportunities to explain their actions, and the Justice Department, time after time, refused to provide basic information. When Boasberg asked how many planes were in the air, they wouldn't say. When he asked about the exact timing of events, they cited national security. When he asked who gave the order to continue the flights after his ruling was communicated, they stonewalled. They invoked state secrets privilege to shield information from the court. In one hearing, Boasberg told a Justice Department attorney directly, and this is from the court transcript, "It seems to me there is a fair likelihood that the government acted in bad faith throughout that day. You really believed everything you did that day was legal and could survive a court challenge. I can't believe you ever would have operated in the way you did." Those are extraordinary words from a federal judge, bad faith. I can't believe you ever would have operated in the way you did. In April, Judge Boasberg issued a formal finding. He said probable cause existed to hold the Trump administration in criminal contempt of court. Let me explain what that means because this is constitutionally significant. Criminal contempt isn't a policy disagreement. It's a determination that someone willfully violated a court order. It can result in prosecution. It can result in fines or imprisonment. And Judge Boasberg was saying he had sufficient evidence to proceed toward that conclusion against officials of a sitting presidential administration. He wrote, and this is directly from his ruling, "The court ultimately determines that the government's actions on that day demonstrate a willful disregard for its order, sufficient for the court to conclude that probable cause exists to find the government in criminal contempt." He continued, "The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it." And then he added this, "To permit such officials to freely annul the judgments of the courts of the United States would not just destroy the rights acquired under those judgments, it would make a solemn mockery of the Constitution itself. Criminal contempt against officials of a sitting administration for defying a federal court order, a judge using words like solemn mockery of the Constitution. When was the last time you heard language like that from a federal court about a president's administration? Drop a comment right now and tell me where you're watching from. I want to know how far this is reaching because this affects every American, regardless of politics." Now, the administration appealed, of course they did. The case bounced between courts for months. The Justice Department argued that since the Supreme Court had later vacated Boasberg's underlying order on technical procedural grounds, the contempt inquiry should be dismissed. In August, a divided appeals court panel agreed, blocking the contempt proceedings in a 2-1 decision. But here's what's crucial to understand. The two judges who blocked the proceedings were both Trump appointees. The Obama appointee dissented, and in her dissent, Judge Nina Pillard wrote, "Our system of courts cannot long endure if disappointed litigants defy court orders with impunity rather than legally challenge them. That is why willful disobedience of a court order is punishable as criminal contempt." The underlying reality remained unchanged. A federal judge had concluded, based on documented evidence and months of investigation, that administration officials deliberately flouted his order. The procedural escape hatch doesn't change what happened on March 15th. Stay with me here, because this distinction matters enormously. This isn't about whether you agree with the deportations. Reasonable people can disagree about immigration policy. This is about whether the executive branch can ignore court orders it doesn't like. If a president can simply declare a judge wrong, defy the ruling, wait for a favorable appeals court to dismiss on technicalities, and face no consequences, then judicial review becomes meaningless. Not just in immigration cases, in every case, environmental regulations, civil rights, criminal prosecutions, all of it. The principle established in Marbury versus Madison in 1803 that courts can declare government actions unconstitutional only works if the government obeys the courts. If it doesn't, the courts have no army. They have no enforcement mechanism except the expectation that the other branches will comply. That expectation is what's being tested right now, and Judge Boasberg understood this. Even after the appeals court blocked his contempt proceedings, he kept working on the underlying case. In December, he issued another ruling. He found that the deportations were illegal, conducted in defiance of his order, and that the migrants had been deprived of their constitutional right to due process. He ordered the administration to submit a plan by January 5th, 2026, to either bring the deported men back to the United States or provide them with meaningful hearings to contest their removal. And here's where it gets even more complicated. By that point, the 137 Venezuelan men who had been sent to SCOTUS weren't even there anymore. In July, they had been transferred to Venezuela as part of a broader prisoner exchange that secured the release of Americans detained by the Maduro regime. The men the administration deported were now scattered across Venezuela, some in hiding, some with no way to contact American courts. Judge Boasberg is still trying to ensure their constitutional rights while they're dispersed across a foreign country whose government the United States doesn't even recognize. This is what institutional breakdown looks like. It doesn't happen all at once. It happens through 1,000 small defiances, each one testing whether the system will push back. And here's what most people don't know. The threats haven't stopped. If anything, they've intensified. The U.S. Marshals Service, which is responsible for protecting federal judges, investigated 807 threats against protected persons in fiscal year 2025. That's an increase from 564 the previous year. In just the first 3 months of fiscal year 2026, which began in October, there have already been over 150 threats recorded. The Justice Department reported in its funding request to Congress that threats against federal judges have, quote, doubled over historic norms, and that the intensity of threatening communications has increased significantly. In March, after Boasberg's rulings made national news, the U.S. Marshals Service issued warnings to federal judges about increased threats specifically related to high-profile cases involving the Trump administration. Judge John McConnell of Rhode Island, who blocked the administration's federal aid freeze, told a conference that his court received more than 400 threatening voicemails after his ruling, including one wishing for his imprisonment and assassination. 400 threats against one judge for one ruling. In September, a group of former federal judges felt compelled to take an extraordinary step. They published an open letter defending judicial independence. These weren't activists or partisans. They were retired jurists appointed by presidents of both parties going back to Jimmy Carter, Ronald Reagan, George H.W. Bush, Bill Clinton, George W. Bush, and Barack Obama. Their letter said, "Threats against judges and their families are obvious attempts to intimidate, harass, and pressure judges and sway their opinions, shaking the public's trust and confidence in the courts." They explained why they were speaking out. Sitting judges are constrained from public commentary. Former judges are not, and they felt a responsibility to defend an institution that cannot defend itself publicly. Congress responded by increasing judicial security funding to $892 million for fiscal year 2026, a 19% increase. That tells you something about the severity of the threat environment. Now, the Boasberg case is just one piece of a larger pattern. In the past year, federal judges across the country have blocked administration policies, birthright citizenship restrictions, foreign aid freezes, transgender military bans, DOJ access to federal employee data. In case after case, judges appointed by presidents of both parties have found that the administration exceeded its authority or violated constitutional rights. And in case after case, the response has been the same. The president attacks the judge personally. Allies in Congress call for impeachment. The administration seeks emergency relief from the Supreme Court, often bypassing normal appellate procedures. Republican Representative Andy Ogles of Tennessee has filed articles of impeachment against multiple federal judges who ruled against the administration. Senator Ted Cruz sent a letter to the House Speaker in January making the case for impeaching Judge Boasberg specifically. Senator Sheldon Whitehouse responded with a point-by-point rebuttal, calling Cruz's letter riddled with inaccuracies. This is where we are. Senators publicly debating whether to impeach a federal judge for ruling against a president. Here's where this gets genuinely concerning for everyone, regardless of your politics. The Supreme Court is set to rule this spring on the birthright citizenship case, Trump versus Barbara. This is the executive order Trump signed on his first day in office, declaring that children born in the United States would not automatically be citizens if their parents were in the country illegally or on temporary visas. The 14th Amendment to the Constitution says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That language has been the law since 1868. The Supreme Court affirmed it in 1898 in United States versus Wong Kim Ark, holding that a child born in the United States to Chinese immigrant parents was a citizen by birthright. Congress codified this understanding in statute in 1940 and again in 1952. Every federal judge who has reviewed Trump's executive order has called it unconstitutional. One Reagan-appointed judge, John Kuffenauer of Washington State, said he couldn't recall another case in his decades on the bench where the question presented was as clear. He called birthright citizenship an unequivocal right that's one of the precious principles that makes the United States the great nation that it is. But the administration is pressing forward. Oral arguments are expected this spring, a ruling by late June or early July. And here's what legal observers are noting. The Supreme Court could have simply ruled on the merits last term. It had the authority. Lower courts had already blocked the policy as unconstitutional. The administration asked the justices to intervene. Instead, the court ruled only on a technical procedural question about nationwide injunctions, allowing the policy to remain blocked but not definitively struck down. Justice Sotomayor wrote in dissent that it was obvious why the administration wasn't asking the court to rule on the actual constitutionality of the order. She wrote, "To get such relief, the government would have to show that the order is likely constitutional, an impossible task in light of the Constitution's text, history, this court's precedents, federal law, and executive branch practice. An impossible task." Those are the words of a sitting Supreme Court justice describing the administration's legal position. Now the court has agreed to hear the case on the merits. Most legal experts expect the administration to lose, but the larger question is what happens next. Will the administration accept the ruling? Will there be another round of defiance, another confrontation? And that's not the only major case on the docket. The court is also hearing challenges to Trump's tariff authority and his attempt to fire members of independent agencies like the Federal Reserve. Each of these cases tests the boundaries of presidential power. Each one could reshape the relationship between branches of government for a generation. Let me leave you with 3 things to remember from everything we've covered tonight. 1. A federal judge found that the Trump administration deliberately defied a court order in March 2025. Chief Justice Roberts publicly rebuked the president's calls for that judge's impeachment. Multiple courts found the deportations were conducted illegally. This is not normal political sparring. This is a direct conflict between branches of government over whether the executive must obey the judiciary. 2. Threats against federal judges have reached unprecedented levels. Over 800 threats investigated in 2025. Congress increased security funding by 19%. Former judges felt compelled to publish an open letter defending judicial independence. The institutional fabric that allows courts to function is under extraordinary strain. 3. The Supreme Court will rule this year on birthright citizenship, tariffs, and presidential removal power. These decisions, expected by July, could reshape the boundaries of executive authority for decades. What happens in the next 6 months will determine whether courts remain an effective check on presidential power or whether we enter a new era where presidents can simply ignore rulings they don't like. I've been covering American politics for a long time. I've seen administrations clash with courts. I've seen controversial rulings and heated rhetoric. Nixon fought subpoenas. Reagan pushed back on judges. Clinton tangled with independent counsels. But what we're witnessing now is different in scale and in kind. The question isn't whether you agree with any particular policy. The question is whether you believe presidents should comply with court orders they don't like. Because if the answer is no, then judicial review, the principle that has constrained government power since 1803, becomes meaningless. The founders designed a system where no single branch has unchecked power. They had lived under a king. They knew what happens when one person can do whatever they want. So they built checks and balances into the architecture of the republic. That design is being tested right now, in real time, in courtrooms across the country, and the outcome is not guaranteed. Make sure you're subscribed with notifications turned on because this story is far from finished. The Supreme Court term is underway, major rulings are coming, and the confrontation between this administration and the federal judiciary is entering a decisive phase. Democracy doesn't defend itself. It depends on people paying attention, understanding what's at stake, and demanding that the rules still matter. I'll be watching, and so should you.